This is Get Your Kids Back Now. This show is dedicated to keeping families together and to fighting the tyranny of CPS and DCFS social workers. A secondary purpose of this show is to educate parents and relatives and to show them, or at least tell them where to go to get the necessary information for their fight. The final purpose of the show is to remind the people that change can be effectuated at the ballot box, at the state and federal levels. So let us unite, vote, and elect those who will make the necessary changes. Good morning. Today's show, I'm going to tell a quick story about a case I had this week. And it shows a very important factor when you're dealing with a CPS case, either as a parent or a relative. And the factor is this: the attorney that you work with, you have to make sure that that attorney is an expert in trial skills. Yes, the attorney should know the law in this area, but in many cases, trial skills and persuasive skills become extremely important. Case in point. This week I did a case, and because the attorney on the other side, the opposition attorney, wasn't prepared for trial, and the attorney knew that we were prepared for trial, we ended up getting a resolution where it was favorable to our client. If your attorney is not prepared when you go into court for a hearing or trial, or what they call a contested matter in juvenile court, it is likely that you are not going to get the outcome that you want. Yes, it's the responsibility of the attorney to be prepared, but I think since this is your family that we're talking about, you should probably assist the attorney in becoming prepared. You should meet with the attorney 1 or 2 times within 7 to 10 days of the court hearing. You should discuss what witnesses you think should be presented. You should discuss what exhibits you think should be presented to the judge. And you should probably do this in writing via email to the attorney, so that when you folks meet together, you both will know what you want to discuss. Many times I hear clients come in and tell me, well, I didn't meet with the attorney prior to the hearing, and we lost. And I only got to talk to the attorney 5 minutes before we went into the courtroom. Yes, that's the attorney's fault, but I also say you bear some responsibility in making sure that your case is prepared the right way. And you can do that by constantly emailing your attorney or calling and leaving messages. I like email. They are saved, and they are saved forever, so that you have proof that you tried to, or that you talked to an attorney or communicated with the attorney about your witnesses and exhibits. If you're going to a contested hearing and you haven't talked about witnesses and exhibits that have been subpoenaed to court or that are going to be presented to court, there's a problem, in my opinion. You must talk to your attorney about that as soon as possible. Don't wait till you've lost the case and you're taking the elevator downstairs and getting in your car and complaining, well, the attorney didn't put any witnesses on, didn't have any documentary evidence. Then it'll be too late. So take some responsibility yourselves to make sure and to help your attorney be prepared.